All rise. Oyez, oyez, oyez. The Honorable, the Supreme Court of Texas. All persons having business before the Honorable, the Supreme Court of Texas, are admonished to draw near and give their attention, for the court is now sitting. God save the state of Texas, this honorable court.
Please be seated. The Supreme Court of Texas is pleased to be able to hear cases today in El Paso, here on the campus of the University of Texas at El Paso. And we came in yesterday evening and have had a very enjoyable time meeting with faculty and students and members of the local bar. And we're glad to be able to do that. In the 19th century, the Texas Constitution required the Supreme Court to sit only in the city of Austin. And that was the law in Texas until the 1990s, and the Constitution was changed to allow this court to sit outside the city of Austin. And since then, we have sat usually twice a year all over the state, in the law schools, but also on college campuses, also on high school campuses. So we are glad to have this opportunity to see the people we serve, and also to have you see the work that the court does firsthand. So we have two cases to be argued this morning. First is 22-674. It's styled in the matter of a trust, Trust A and Trust C, and it's from El Paso County and the 8th Court of Appeals District here in El Paso. The second case is 22-889. It's Oscar Renda Contracting versus Bruce, again from El Paso County and from the 8th Court of Appeals District. The court has allotted 20 minutes for each side to argue, and we'll take a brief recess between the arguments before we conclude the two of them. So we're ready to begin this morning in 22-674.
May it please the court, Mr. Paoli will present argument for petitioners. Petitioners have reserved 5 minutes for rebuttal.
Mr. Chief Justice, and may it please the court, Henry Paoli on behalf of petitioner Mark Fenenbock. In this case, the words of Bernard and Jeannette Fenenbock, the settlers of the Living Trust, are clear, direct, and unambiguous. In any instance in which two co-trustees are serving jointly, any action of the trustee shall require the joinder and consent of both co-trustees. That's contained in Article 10b-4 of the Living Trust, found at the clerk's record, page 48. This case presents the important question of whether Texas trial courts have the jurisdiction and the authority to ensure that the last words of a settler of a living trust mean what they actually say.
Can I just ask you to make sure that we kind of hone this down? So, am I correct that both parties agree that this is not a jurisdictional issue?
That's correct. Both parties, with respect to the petitions for review that were filed, agree that the 8th Court got it wrong in ultimately deciding that the probate court lacked the jurisdiction to grant the relief that it did.
The failure to join may be a problem in one way or another, but it's not a problem in the sense that it deprived the trial court of jurisdiction.
We would submit that is the case. That's right.
And then, does everybody agree that these shares have to go to the Glenagatti Trust?
Ultimately, with respect to the transfer of the shares at the appropriate time, and subject to an appropriate determination with respect to value.
Sure, value you disagree about, or at least you disagree about your client's right to participate in the process of determining value. But in the end, there's no dispute that these shares are supposed to go to her trust and then to her successors or heirs, right?
That's right. The living trust contemplates that the shares will ultimately go to her trust, with assets of equivalent value being set aside as determined by the settlors on behalf of petitioner Mark Fenenbock.
So if that is the case, that it's uncontested, that those assets should be directed to the Linda Gaddy Trust, why isn't this case simply a lawsuit that determines substantially equivalent value for your client? Why isn't it simply an exercise in valuation so that equivalent trust assets can be transferred to him? Why undo the transaction?
Because allowing the transaction to stand has the effect of unilaterally taking out Article 10b4 of the living trust. It effectively transforms what should have been a joint decision into a unilateral decision.
There's no decision to make. I mean, you agree that it goes to her trust. All these shares go to her trust, and you agree to that. So there's no joint decision to make because you both already jointly agree to that. The only question is what's the value and what does he get in terms of assets to match that value?
I don't think that's entirely correct, Your Honor. The issue here is, yes, ultimately there needs to be a transfer of the shares, but there has to be some determination made with respect to what's the appropriate time frame. When did the shares actually get transferred? Under
That
Article
matters,
10,
but
Section B, that should be a joint decision.
That matters because of the dividends, right?
Correct.
So your contention is that yes, it needs to be transferred, but it shouldn't have been transferred a few days before the dividends were to be paid, the $6 million in dividends, and that should have been part of the residue to be divided, not something that went along with the stock.
That's right, because the living trust specifically identifies the stock as part of the residuary. And because it's part of the
Isn't all of
residuary,
that, I mean, can't experts determine value as of a particular date? I'm trying to understand why you actually need the stock back in the trust to come up with a valuation.
because there has to be some determination made, and the probate court recognized this, that in order for the settlor's words to actually have meaning, there's supposed to be some agreement reached. And if they can't reach an agreement at that point in time, certainly Fenenbock has the right to submit his own valuation expert and opinion and have a legal determination with respect to that. But what happened here was that his rights as a co-trustee were basically invalidated.
So that sounds like a procedural objection. And I'm wondering, we've got a brother and a sister sadly engaged in litigation using an awful lot of the assets that their parents left to them instead of finding a way to do it to pay the lawyers in order to solve it over a procedural dispute. Now, I wonder, can you tell me how it really is different from this? What if the brother and sister had a deal where in successive Fridays, one gets to pick what they're going to have for dinner? And so one of them goes ahead and without consulting the other when it was their turn, orders pizza. And the sister does that. And the brother says, wait, it's my turn. It's my turn. Throw that pizza in the garbage. Okay, well, what do you want? Well, I'd like some pizza. Is that essentially what we're having here? It works out exactly the same. We're going to get the same result. It's just destined that these shares are going to be in Lena's trust. If the problem is that 3 days after the valuation of $3.4 million, there was a $6 million dividend, I get that that suggests, well, maybe that valuation wasn't very good. If an asset has a revenue stream like that, probably it was worth a lot more than $3.4 million. But that's something that can be handled aside from throwing out the pizza or restoring the shares themselves to the larger trust. Why is that not the way we should be thinking about this case?
I don't think the court should think of the case that way because it essentially undoes and invalidates what the settlors intended with respect to joint decision-making.
The settlers also intended those shares to go in a particular way. They knew that that was going to happen, and you've agreed it's inevitable. So why undo something in order to achieve a procedural process that cannot lead to any different substantive outcome?
Because the substantive outcome can be substantially different depending on two factors. What is the relevant date of the transfer? That Glenna didn't have the unilateral right to make that decision, and what valuation do we apply?
Well, the terms of the trust dictated the transfer. And so, you know, your argument is, well, my client can mutually come to an agreement about that transfer. So are you saying that your client could basically withhold consent to the date of the transfer for 20 years?
No, I'm not saying that. The probate court recognized that the appropriate time for them to make a determination with respect to an attempt to reach an agreement should be after the shares of stock are restored back to the trust. Because ultimately what it does is that by allowing the unilateral transfer without the consent and participation of the co-trustee, we've invalidated the rights of the co-trustee to participate in the decision.
But in a situation where the terms of the trust take away the right of the co-trustee to direct specific assets, what part of the trust agreement should be given more weight? The directive about particular assets being transferred to a particular place, or the more general and less specific directive that there should be, with respect to other assets, joint decision-making?
No, I think Article 10, Section B4 doesn't specifically identify or exclude the shares of stock as something that can be subject to a unilateral decision. And of course, a fundamental rule is that the court has to consider all of the provisions in the trust agreement to determine their meaning. We can't invalidate one section in terms of focusing on another section. There's no limitation in Article 10, Section B4 that suggests with respect to these specific shares of stock that a unilateral decision could have been made. And let me give an example.
Is your client, by withholding consent to transfer these assets in accordance with the terms of the trust, is your client not complying with the terms of the trust?
I don't think so, Your Honor. I don't think there's any question with respect to that. And the reason for that is because the relief that was sought in the probate court was restoration of the shares of stock. The probate court directed the parties to attempt to reach an agreement with respect to ultimately valuation, and if they couldn't reach an agreement, well then Fenenbock was given the right and the opportunity to submit his own valuation. But the appropriate time to make that determination has to be when the shares of stock are restored, because otherwise we're essentially reading out Article 10, Section B4 from the living trust.
So if we agree with you, so number one, this isn't jurisdictional, and then we agree with you that these shares should never have been transferred, and either with or without the sons being joined in some way, the trial court has to undo the transfer of the shares. They go back to the larger family trust. Now's the time to distribute, right? I mean, under the terms, there's no reason why they shouldn't be distributed back to Glenna's trust right now, or as soon as the trial court gets them back into the family trust.
Yes.
Now's the time. And so they're
Subject
going to be distributed pretty much right away after that. There's no reason for delay after that.
Well, subject to some determination with respect to the co-trustees acting jointly to determine date and valuation.
Okay,
That's
sure.
right.
So, yeah, well, but you say there might be some need to determine date, and I guess if you mean March 2nd instead of March 1st or whatever, but there's no reason to wait till 2026 to do it, right? I mean, under the terms of the trust, they should be distributed back to Glenna's trust. There's
That's
no
right.
reason for a delay on that.
I don't think there's any reason to have any unreasonable length of
And if the delay
time.
matters, if it's going to happen March 1st of 2024 instead of back when it happened before, the effect is the value of the dividends that you were discussing with Justice Busby. Why can't that just be taken care of as a matter of damages?
Because it doesn't fully adequately address the rights of a co-trustee with respect to a right to joint decision-making.
Why not? Because it'll put him right back where the shares will go to Glenna's trust. He'll get whatever money he's entitled to as if they had been transferred on the right date, whatever that may be. I mean, why can't that all be resolved as a matter of damages?
It's not solely a matter of damages because there has to be some determination made as to what is the appropriate date and what is the appropriate valuation.
Sure, but why can't that be done without sending the shares back and forth?
It can't,
Because the reason those two things matter is a dollar number, right? I mean, that's why that matters to your client, both time and value. They are important to your, I get it's also important to your client, just sort of the principle of the matter, that I should have gotten to participate in the decision. But he didn't. So we got to fix that. Why do we have to fix it by transferring them back and forth when the only practical difference is a dollar number? Why can't the court just come up with the right dollar number?
it shouldn't solely be a damages question because damages won't necessarily fully vindicate the rights of a co-trustee to participate with respect to decision-making. It will, to a degree, impact the rights of a beneficiary, and Fenenbock stands in a joint role. He wears multiple hats as a beneficiary, but it doesn't fully vindicate the rights of a co-trustee to participate in equal decision-making.
That
What
sounds
about
like
the fact-
please.
What about the fact that the remedy that the trial court ordered was to restore stock that Glenna no longer owns? Right, so in effect, the trial court is ordering her, requiring her to do something she can't do, or if she can do it, I'd like to know how she might do that. Seems to me as if it's the equivalent of me inheriting a house, deciding I don't want to live in it, so I'm going to sell it to someone else, and then later a trial court comes around and says, give me the title to that house. How can I do that?
Well, keep in mind, Your Honor, we're not at the point currently of any type of contempt or enforcement proceeding. And so our argument in large part has been a lot of those concerns we believe are premature to the extent that Glenn is trying to raise his bona fide purchaser defense.
Why are they premature? It's pretty clear from the Declaratory Judgment Act that the order can't have any effect on the right of third parties.
That's right.
So why can't Glenna just say, I don't have it anymore, so, and this doesn't have any impact on the people who do have it, so, you can't hold me in contempt because it's impossible for me to comply.
Well, with respect to impossibility, there's cases decided from this court that recognize impossibility can't be raised as a defense when the party ultimately causing the impossibility is the person who's responsible for that. We cited those cases in the brief. Specifically, there was the tractor case with respect to the party who attempted to say, well, I don't have to convey back a tractor that I sold to someone else.
Right, yeah, and I looked at those cases, but I guess what I'm saying is why should the court's judgment be read even to have the effect of requiring her to do that, even though it says that, because the law says it can't do that. The law says it can't affect those rights because it only binds the people that are in front of it.
Correct. We believe ultimately the declaratory judgment order at issue and the relief at order binds the parties who are actually before the court. So to the extent that her sons want to raise a bona fide purchaser defense, that issue's never been ruled on by the probate court.
Well, they don't have to raise that defense because you don't have any order for them to do anything. You haven't sued them.
Correct. And ultimately,
so there's no need for them to raise a defense.
Well, in terms of thinking going forward, if there is some type of enforcement proceeding in terms of a bona fide purchaser defense, the appropriate time would be to raise that at that point in time.
How could you possibly hold her in contempt if she can't restore the property? Are you talking about holding her in criminal contempt?
No, I'm not talking about a criminal contempt proceeding.
She doesn't have the keys to the prison in her own pocket if she can't restore the property.
Correct.
So it can't be civil contempt either.
Correct. What I'm focusing on with respect to that is that the ultimate issue of impossibility, that's something that was created by the Glenna making a decision that she believes was done in good faith, arguably wrong, we believe, under the terms of the trust. And so should she be rewarded by that conduct by being able to raise that impossibility defense and this arguable bona fide purchaser defense? If the transaction was void, as recognized by cases from this court because it was done without compliance with the terms of the living trust, that impossibility defense, this bona fide purchaser defense, ultimately they're not valid defenses to her conduct, and she shouldn't be able to justify those.
Can I just ask why, if you really want to get the shares back and you know that she doesn't have them and you think you know who does, why not join them? And why have this big fight about whether they're necessary parties under Rule 39, what the consequence of that? Why not just join them in the beginning?
Well, they could have been joined, but ultimately we didn't think it was necessary because they made no affirmative claim with respect to trying to seek some intervention in the case.
But they did make a claim to the property. They bought it.
Correct, but that ultimately is not the final determination with respect to Rule 39. I think Kapmeyer addresses that issue partially. They didn't take any affirmative action to
That's kind of
assert that.
attenuated in Catmeyer, wasn't it? I mean, those are people that might have an interest in whether or not this fee could be raised and whether these particular people had to pay the maintenance. Here we're talking about the shares, that's it, and they're the ones that you say own them. How is that? That seems worlds away from Catmeyer to me.
Well, keep in mind, the disclosure with respect to the shares being transferred, that was something that was made by Glenna in response to the motion. There was no prior disclosure with respect to that. I think that the focus with respect to Catmeyer focuses on, well, was there some affirmative claim made such that the parties' rights could be affected, even though they had some ultimate right with respect to the proceeding that's at issue? And for that reason, we don't think Catmeyer provides any limitation. If I may reserve the remainder of my time, I don't want to cut you off, Justice
No,
Black.
you'll get your time. I think the other side argues that there's no allegation of improper benefit, and it's uncontested that there are sufficient assets remaining in the trust to cover the substantially equivalent, reasonably equivalent value of the shares. What's your response to that? Because that would be, they say, necessary before you could void the transaction.
Yeah. The improper benefit is that to this day, my client has not shared in any of the dividends or the purchase price that Gaddy received from her sons in connection with the transfer of the stock. Even though under the living trust, he is supposed to receive equivalent value. We've been litigating this case and he's never had a right to receive either of those. And because the stock is part of the residuary, he's entitled also to a right to receive income from the shares. And that's the improper benefit that only Glenna and her sons have received to date. I may reserve the remainder of my time. Thank you.
Excuse me.
Justice Lamberton has a question.
I'm still not really understanding your answer to Justice Young's question, because it seems to me that joinder could have just solved all of this.
Well, it potentially could have, but keep in mind, Your Honor, at the time that we filed the motion to declare the transfer void, we had no information whatsoever with respect to the transfer. And ultimately, here we have a situation in which the co-trustee who owes fiduciary duties to Fenenbock as a beneficiary, she has the burden of proof with respect to proving the fairness of the transaction. She has the burden of proof with respect to showing adequate disclosure in order to establish that she did not breach her fiduciary duty. The first disclosure that happened with respect to the transfer was when Gaddy submitted her affidavit or her declaration claiming, well, the reason I cannot comply with the proposed request in terms of the motion that was sought was because I transferred the shares, and that was the first disclosure that was actually made. And that's the reason ultimately here, we didn't seek a joinder prior because it was ultimately not known. Only Glenna had that information. We weren't disclosed about it prior to that point in time.
Any other questions? Thank you, counsel. We'll hear from the respondent.
May it please the court, Ms. Greer will present argument for respondent.
Good morning, Mr. Chief Justice, and may it please the court. I want to clear up one thing. The first disclosure of this transfer occurred soon after it occurred. Mr. Fenenbock filed suit in May.
Why transfer the shares before reaching an agreement about valuation? And if you hadn't reached an agreement about valuation, seeking some determination of valuation on the basis that the trustees couldn't agree to it?
Well, first of all, she had a valuation done by an independent third party.
Right, but there was no agreement about that, and there was no, so ordinarily you would think stock transfers according to the terms of the trust, other beneficiary receives their equivalent value for that stock, but only half of that was completed by your client. And so what do we do with the fact that the transfer occurred, but we still are here today, years later, and there has been no transfer of equivalent assets?
Well, I think Ms. Gaddy fully intended that there would be a discussion that she would present. This was not a unilaterally imposed value. I think that those terms have been used in the briefs. That is absolutely incorrect. Mrs. Gaddy has been inviting her brother to engage in a valuation process for years. We filed a motion under 166G asking for the court to determine the date and determine the value. Set up a process, let us brief it. We've got 3 valuations that we've produced, all completely independent and all completely
What is
independent
the
of each
range
other.
of those valuations?
It's fairly within the same number. It's a valuation of the company, and they're within the same range. Mrs. Gaddy would take any of those at this point.
So let me ask, just out of curiosity, how can there be evaluations at 3.4 million?
3.2.
3.2 million. 3 days later, there's a $6 million distribution of dividends. That doesn't sound like a plausible valuation of something that has that capacity for a revenue distribution of basically double the entire valuation of the shares.
Well, first of all, the $6 million was a distribution to all the shareholders of this company, W. Silver. The distribution that Mrs. Gaddy made to her sons that they purchased was approximately 32% of the company. Each got about 16%. So they didn't get that whole distribution, and that distribution was a recapitalization that had been planned for some time. It was nothing secret or carried out in any way. And it doesn't matter because Mark was never entitled to that. The stock bequest is a specific bequest. There's no question about that. It meets the test, the long-standing test. It is specifically identifiable as a race. We know that. They've made the same argument in making the constructive trust argument. They can't make a constructive trust argument without an identifiable race. So that's conclusively established on this record. The second part is, did the testator intend that specific asset to go to this specific person? Well, that's conclusively established on this record, too.
It's undisputed. They said they agree that sooner or later the stock has to go to Glenna.
Exactly, but what
But
they're
it does seem to
arguing...
be disputed about whether the dividend should go with the stock, and that seems to depend on the time of the transfer.
No, not really, Your Honor. That depends on whether it's a specific bequest or not.
The dividend?
Yes, because
Where was the dividend a specific bequest?
or the distribution, because it follows the stock. Under section 116.051, the income follows the specific bequest from the date of death. And there's also the case Hurt v. Smith, which we've cited.
But certainly you could, the income-producing nature of the bequest would be used as part of the valuation to transfer substantially equivalent assets.
Not if it's a specific bequest. It may be, yes, it may be used as part of the valuation. I see where you're going with this. That's correct, but that's a numbers issue. That's a valuation issue. And I think the court's questions, if I'm reading them correctly, are clear that timing and valuation are money issues. They're not equity issues. No purpose is served by having to retransfer and redeposit these shares into a bank account owned by the trust.
Well, other than the formality of saying the trusts need to be administered according to their terms, and that they're making, it is a procedural argument. I agree. It seems like we can get to the same financial outcome, but there is something to be said about the idea that trust must be administered properly.
Absolutely, and there's an answer to that, because as the court is aware, Mrs. Gaddy had no idea that her brother would claim to be a co-trustee. His claim is based on a First Amendment, to the trust that we interpret differently, quite frankly.
You didn't appeal that, right?
It's interlocutory.
She no longer disputes that, though? She now no longer disputes that he is and should have always been a co-trustee?
I don't know if we might take that position after final judgment. It may be moot at that point as a practical matter.
She certainly doesn't concede it, but she's not disputing it at this point.
We're not disputing it for purposes of this appeal. We're trying to make it as simple as possible. So assuming he is a co-trustee and he has an equal right to consent, that consent may have been violated because she was unaware that he was a co-trustee. That's clear. She had no idea. There's no evidence in this record. That came after the fact and when he filed the lawsuit. And so she did it thinking she had the authority and the power to do it. If it's wrong, if it's defective, that's a question of voidable, not void. And this trust section that they're going under deals with, not the trust, the statutory provision they're going under, 114.008, deals with void orders. The order says this transaction is void. Well, void means it's incapable of ratification. This court recently, touched on that issue in Concho Resources versus Ellison. Void is incapable of ratification or acquiescence. Well, that's not how trusts work. Under the restatement third of trust, which both parties rely upon, section 39, an action of a co-trustee can be ratified by the other co-trustee. And as we've pointed out, Mr. Fenenbock has a duty to agree to the stock transfer. he will be in breach of his own fiduciary duty as co-trustee if he does not consent to this transaction. So
Is
his
your position
withholding.
that he has a duty to do that before there's an agreed value?
I think it is, because I don't see that the agreed value is necessarily tied to when the stock gets transferred. The reason she
Well, but
did
it
it.
might be because he's supposed to receive reasonably equivalent value. Why wouldn't that be at the same time?
Well, ideally it would be, and that was certainly her intent. She presented him with the valuation.
Well, it's very
And-
different to say, I present you with a valuation than when you've got two co-trustees who are supposed to be working together to do that.
Again, she did not know he was claiming to be a co-trustee at that point. She had no idea. She's the sole executor under the
Right,
will.
well, but I don't understand why it would matter what her intent was for purposes of any of this.
Because it had already happened.
But that doesn't affect whether there was a violation or not.
Well-
It's not a scienter standard for whether there's a violation, right?
No, but the point is it can be ratified. I mean, Bogert, one of the treatises that we both rely upon, says, quote, when a single trustee seeks to exercise a joint power, the invalidity of his action may be cured by a later, and this is an emphasis in the treatise, ratification or acquiescence by the non-acting trustees or by court order.
It sounds like he's not agreeing.
And that might be why we have to go to a court order. We're trying to engage the process. We've done everything we can to present.
One thing you could have done would be to have joined Glenna's sons. That didn't happen from their side, didn't happen from your side. If
They're
that had
not-
happened, would that not have simplified things considerably?
No, I don't think it would, because they're not, from our view, the stock shouldn't have been ordered retransferred. They're not implicated by this, and they shouldn't be implicated by this. It wasn't her job to bring them in. They wanted this extraordinary relief of a mandatory injunction that has no precedent, and that it was their duty to do what it took to get that relief
If
and
they
show
were
equity.
right, though, if they were right that the sons had to, well, let me back up. On this joinder issue under Rule 39, I'm right that both parties agree that's not a jurisdictional issue. If they should have been joined and weren't, that did not deprive the trial court of jurisdiction. You agree with that?
Absolutely.
Okay. And so then, but let's assume that they should have been joined, they claimed an interest, or for whatever reason, or maybe under the Declaratory Judgment Act, they should have been joined. And so now we have to decide, what do we do with the fact that there was this determination made without them there? So we all agree it doesn't bind them, all right? You agree with that?
Well, if the yes and no. I mean, if Glenna Gaddy can be held in contempt of court because she can't do what the court has ordered, then I think, or if the stock is somehow restored, they've been deprived of their rights. I mean, it's really strange how the court.
Let's break it down into distinguishing between declaratory relief and injunctive relief. Certainly, the trial court could declare that the shares, that the transfer was either void or voidable because he was not permitted to participate as a co-trustee, and that would be a binding declaration as to these two parties, but would have no effect on the sons.
Well, I disagree with that, Your Honor. It has a practical impact that is significant, and that is that it is creating uncertainty over 32% of the ownership of a successfully operating company.
Well, then parties have to figure out some way to get to court to resolve that uncertainty. For whatever reason, these two parties don't want to bring them in to do that. So if the sons care enough about the uncertainty, they would have to file their own lawsuit so they could finally be bound.
Well, it's our position we don't even get there because it's an issue of valuation. And all we need to know is the date. Again, we've asked the probate court for the date. We've asked the court to make its own valuation, appoint a court-appointed expert. Whatever it's going to take to get this number, Mark will not engage. He has never even provided specific criticism of any of the valuations that have been provided by these third parties, including a judge.
Why not affect a transfer of one of the valuations, even the lowest valuation that you've received? Why not affect that transfer?
I mean, Mark, if Mr. Fenenbock would agree to that. I mean, so far we haven't been able to agree on anything because their position is until the stock is retransferred, And again, this is almost 7 years since these transactions occurred, and we are just now at this point.
Why isn't there independent value apart from the money in vindicating the parents' desire that the children administer the assets together?
Well, there could be independent value in that, but the point of that is it's solved by ratification, because ultimately Mark has to agree to this transfer.
So I think your point on ratification is not that he's agreed, but because the transaction can be ratified, it's a voidable transaction, not a void one.
Correct.
And I think their response to that is, under the trust code, there was an improper benefit because Glenna retained benefits associated with the transfer of the stock without conferring onto Mr. Fenenbock the reasonably equivalent value of that stock.
Well, with all due respect, Your Honor, that's a self-inflicted wound, because we are prepared to agree. We have tried to agree.
So your point is you can't withhold agreement in perpetuity and run up the damages or the value associated with the transaction.
Correct, and hope that the company continues to be more and more successful and try to pick a date where he'll get more of the equivalent value.
But that sounds like a claim you would have against him for breach of fiduciary duty. Have you brought that claim?
Not yet. We're trying to get this resolved, because what Mrs. Gaddy would want most of all is to wind up her parents' estate, her mother's estate, as her mother intended.
But that's not before us or any court at this point, whether consenting or withholding consent was a breach by Mr. Fenenbock.
No, it's not before the court. We're just trying to get evaluation, because we feel like if we could get evaluation, we can hopefully wind up there are only two major issues left.
But that issue, compelling evaluation, is also not before us.
It's not before you. It's before the probate court, but everything's been stayed pending the outcome of this appeal.
If we agree with both of you that this is not a jurisdictional issue, the joinder problem is not a jurisdictional issue, we never get to fundamental error issues here?
Correct.
Okay.
With respect to the parents' intent, it seems to be the case that the intent was for the siblings to work together. And one might gather from a trust that's set up that way that the parents were more concerned that their children work together than they were about who got what. And so I'm concerned in this case about a rule that would encourage litigation over the assets as opposed to maximizing the incentive that the courts give people in this kind of a situation to work together.
I understand that, Your Honor, but the point is sending the stock back to the account accomplishes nothing. It's not a void transaction. It's voidable at best. And so it can be subject to ratification by the court, and that may be the next step we need to take when we get back to the court, is to get ratification through the court or Mr. Fenenbock. And so, you're talking about a nuclear response to something that should be fixed by a proper jurisprudential procedure in place, which is to basically come up with valuations, and then the court may have to pick or appoint its own court-ordered appraiser, as Judge Villa did in the other Fenenbock case brought by Mr. Fenenbock's daughters.
Does the terms of the will or the trust agreement, did they become effective upon the death of their mother? And so was Mrs. Gaddy's entitlement to the specific bequest of stock, was she entitled to that immediately upon death, or was there some timing?
Yes, Your Honor.
Either the trust or the will.
According to the trust code, she was entitled to it at the time of Mrs. Fenenbock's death, which is why there's no issue really with the dividend, because she acquired the asset at that point. And so this was just a formal transfer of the action.
Did it vest automatically, or was there some action required?
The trustee was to transfer it, but it has to do with tax purposes. There are aspects of it that vest at the death. And then there are aspects of it where the transfer had to occur, which is why it occurred the way that it did.
So what would the tax consequence be of saying that the trustees didn't have to agree to transfer it?
I don't know that there would be a tax consequence. The tax consequence is that Mrs. Gaddy and whoever owns the asset would be liable for any tax on the distributions or income after the date of death.
One aspect of this case is this impossibility, the idea that it's impossible for her to perform what is commanded, restore these shares. So I wonder, what if instead of it being shares in a company, it was a Ming vase, and the allegation was, well, she took the Ming vase, and that really was something that we had to decide together, and et cetera, et cetera. And the court says, yeah, return the Ming vase. And she says, I'd love to, but last week the dog jumped up on the table and it smashed into dust. Here's the dust, that's all. That's impossible to perform at a certain level, aside from giving it to some other person. What would the law do in that situation?
Well, I mean, I would argue that you wouldn't be subject to contempt, but the problem is this is a lot more murky because of the way that it's been argued and presented to the trial court. And I don't think that it's unclear as to who is to restore it. So we have a double problem in this case. It's not just the order that you're talking about, return the Ming vase. We've got a who is to return it, who is to restore it.
Let's just assume, for purposes of this perhaps silly example, it was Glenna who took the Ming vase, she put it in her own trust, and then she put it in her house. She's supposed to return it to the archivist that maintained the family property or whatever, so they could together decide what to do with it. And my assumption is, well, if the vase has been destroyed, there's no way she can comply with that. It's literally impossible. But it's not impossible to say, well, we can get a bunch of fine art appraisers to say what the value of the Ming vase was at the time that she wrongfully took it, and that must be presented to the court or to the trust or whatever in exchange. Is that not the kind of thing that would happen, even if assuming, yes, it was wrongfully taken, I should restore it, but I can't. For whatever reason, I just cannot do it. I don't have it. Is that not how these problems would be solved generally?
I think that would be the right way to solve it. Again, it's a question of valuation, and especially when the parents made it very clear exactly that was exactly the way it was supposed to happen. Glenna got the stock, he's to get a reasonably equivalent value. All we need is a date and valuation to be decided by the probate court if the parties can't agree. And we've been trying. We would like to resolve this, but you're right, there is an impossibility, and whether it was imposed by Glenna or on herself or not, we don't even really get there because there's no purpose in ordering the unraveling of all these transactions. Nothing's to be served. It's all gonna have to be done right over again. And, again, there's more than enough assets. I want to make it very clear, the last appraisal or inventory of the estate had it appraised at more than $5 million. The trust has at least that much in it. So there's more than enough money based on any valuation that Mark might come up with.
What if it was $6 million? What would happen if the shares were worth more than the rest of the trust?
I think you would have a different situation. There might be a remedy and damages against the trustee. I'm not really sure. The beneficiary would need to be made whole, but we don't have that problem here because the will pour over into the trust, and that $10 million plus will be is pretty much liquid because Ms. Gaddy has done a great job of handling the executor duties.
Any other questions? Thank you, Ms. Greer. Mr. Paoli, you have 5 minutes.
One point I want to emphasize to the court is the court has petitioner's oral argument exhibits. Tab 1 contains a contrast between what parents, Bernard and Jeannette, did when they identified specific gifts versus a residuary gift. And tab 1 shows the court that Bernard and Jeannette, in their will, specifically knew how to make specific bequests. They titled them specific bequests to Glenna, specific bequests to Mark and Glenna. But then with respect to identifying the W. Silver recycling stock, the settlors and the testators specifically chose different treatment. They identified it under the title residuary bequest. They identified it by describing the trust remainder in equal shares as including the W. Silver recycling stock. I think that exhibit shows the court that, contrary to my able counsel's argument on the other side, the W. Silver recycling shares of stock were not a specific gift. They were a part of the residuary. And under 116.051 of the trust code, because they're part of the residuary, Fenenbock has a right to share in the income that is paid in connection with that property.
Right, but does he have a right to withhold his consent to the transfer with the idea of waiting for years for the value of the stock to potentially increase in value before effectuating the transaction? In other words, just, it inures to his benefit to withhold and see if the stock goes up in price.
Your Honor, quite frankly,
And then can argue, if it went down, he could argue, no, I get the valuation at the date that, at the date of our mother's death. If the stock goes down, if the stock goes up in value, I get the valuation at the date of death plus all the value that's been captured while I haven't agreed to the transaction.
Your Honor, that's not what my client's trying to do.
Okay.
There's been no attempt done to do that. The reason why
And
we're
there's no
delayed.
claim- There's no claim against him for that, right?
Correct. There's no active or asserted claim in the case. There's nothing in the
But
record
just
to
in
indicate
terms of
that is a claim.
valuation and damages,
I'm sorry?
just in terms of valuation and damages, there is a sort of wait and see to see what happens.
That's correct, Your Honor.
Unless you fix the date at the date of death.
Correct. And ultimately, part of the reason we're here is because the court system has gone on, and as the appeal has been prosecuted. Yeah. It's not a question of my client trying to just sit back and say, well, I just want to wait around forever so that the value of the stock in the company goes up, and then therefore we need a determination with respect to that.
Even though the determination that he is a co-trustee is not been reduced to a final judgment, do you concede that at this point your client has an obligation to act as a fiduciary and to protect Glenna's interests?
Yes, in his role as a co-trustee. I will disagree, I think, with my able counsel's argument with respect to whether that is an appealable probate court order under the De Ayala test. I pointed that out because I think that ultimately that determined that discrete phase of the proceedings, and there was never an appeal filed in connection with that summary
So you think it is final?
Correct. I do think it is final. It's not reduced to a final judgment in the traditional sense, but of course in probate courts we have a different standard that applies under De Ayala.
Okay. And so your client at this point you think needs to act in accordance with those duties, and do you perceive some risk for your client in not agreeing to move the process forward in terms of coming to the table with evaluation?
No, I don't think so at all, Your Honor. And the reason for that is because what the probate court contemplated here is that in order to vindicate Fenenbock's rights as a co-trustee, we need to restore the stock. And ultimately, that's the appropriate time to make a determination of value. The fact that multiple years have passed, ultimately since since the transfer occurred, that's ultimately just part of the court system, and the fact that there are some significant legal issues in the case that both our El Paso Court of Appeals and now this court is ultimately trying to address.
What about the Ming vase example I asked your friend on the other side? If that was what needed to be restored because your client did not have the opportunity to participate as a co-trustee, but it's just a big pile of dust and rocks at this point, what do you think would happen then?
I think in that limited example, if there's ultimately impossibility because the ultimate property is no longer subject to being restored, in that limited example, then you would probably just have a claim for damages.
And so that impossibility was also caused in the same way that the impossibility was caused in this, to the extent there is any, by Glenna. Your argument is we have cases that say if the defendant is the one that caused the impossibility, we won't entertain that argument. And so if what she took were the shares causing the impossibility, took was the vase causing the impossibility, you're saying we can entertain impossibility if it's a Ming vase that's destroyed, but not if it's shares that have now been sold and resold and resold.
Yeah. Your Honor, I think the example is a good one in contrasting. There's a difference between an accident and a person making a conscious decision to do something that puts them at risk of violating a fiduciary duty, that they have the obligation to prove. This case is the first situation or the latter situation. I think your example ultimately arises from a situation in which a person literally has no control over the impossibility that's
But
created.
they are the ones that took it out wrongly. So it's still at least a but-for cause, but you're saying it's severed because of the dog jumping on the table.
That's right.
Can I ask you one last thing for me at least? Given that the parties agree, and if the court agrees that the Court of Appeals was mistaken in its view of subject matter jurisdiction, should we just remand it to the Court of Appeals and say, look, you thought you didn't have subject matter jurisdiction, we can now confirm that you do, so proceed and resolve the rest of the parties' dispute without this court taking any view on any other question or not?
I think that's a possibility, Your Honor, but I don't think that's appropriate here. In many of the cases that the court addresses in the context of fundamental error, you have courts of appeals ultimately not addressing the merits, and then ultimately when it does come to this court, the court actually does address the merits because the fundamental error analysis was not appropriate. I think under Rule 60.2b, that rule contemplates that the court can reverse the lower court's judgment in whole or in part and render the judgment the lower court should have rendered.
I don't dispute that we have the discretion to resolve the merits, but given that the Court of Appeals has not reached any of them and there's all of this murkiness between the parties, would it not be wise for us to allow the Eighth Court to do that?
You know, I think the simplest answer to that question is I think both parties, after multiple years of litigation, I think this process has now gone on for about 7 years, they ultimately do want a determination on the merits. And at some point
I see
in
a
time,
head
that
nodding
needs to
on
be
the other
addressed.
side, yes.
That's right.
That's not me. Okay.
If I may, Chief, just one follow-up. Do you agree with the respondent that if the transfer was inappropriate, as your client contends, that it makes it voidable as opposed to void?
No.
Okay, and could you just give us the citation to help us know the right legal answer to that question?
Correct. It's two things, Your Honor. It's Section 113.085 of the Trust Code, which contemplates that co-trustees may act by majority decision. And secondly, it's this court's decision in Slaughter versus Qualls, 139 Texas 340. That case recognized that a trustee who sold real estate under a deed of trust that was contrary to the actual authority granted by the deed of trust did not convey good title, and that transaction was ultimately void. And so if the court is going to consider and vindicate the rights of a co-trustee, I think those are the two most relevant authorities to consider.
Any other questions? Thank you, Mr. Paola. The case is submitted, and the court will take a brief recess.
All rise.